In this lesson, we will begin part 1 of company law by having a look at the forms of business organization. Now, essentially, this entire course will be centered primarily around companies, both in its private and its public format. But having said that, there are a number of different ways that an individual or a group of individuals can get into business. Firstly, you have the sole proprietorship or the sole trader, where there's an individual that goes into business on his own account. You have partnerships, where a group of individuals get together, and you have the bulk of this subject, which is companies. But before we go into company law, let's have a look at the sole trader or the sole proprietorship. As I noted earlier, a sole trader is someone or an individual who goes into business on his own account. There are a number of advantages and disadvantages of doing business in this manner. When your outfit is quite small or limited, it is much better to be a sole trader or a sole proprietor as opposed to, let's say, a partnership or a company. Primarily because there are no formal legal requirements, or for that matter, any other requirements. The moment you start conducting your business is when you'll be considered a sole trader. Apart from that, all the profits and the benefits that are associated with your business will be solely enjoyed by yourself only. These are the primary advantages. But much like those benefits and profits accruing to only yourself, so too, as much as a disadvantage could be considered, does the liability, because it is quite personal. And you'll notice how this is distinguished from companies later on, where you have a veil, so to speak, between your personality and that of the company. But when it comes to a sole proprietorship, if you're a sole trader, chances are the liability will be imposed on you personally. Essentially, you're doing business on your own account, in your own name. Apart from that, your business, as I noted earlier, is quite limited as well, because the chances for raising capital are limited to your own sole self. It's very difficult to ascertain capital from other investors as well as the public at large, much like in a company, when you are conducting yourself as a sole proprietorship or a sole trader. This in turn means that there's a higher operative risk that's involved, since all the burdens, as much as the benefits, are accrued or are stipulated on you as an individual. Contrary to this, you have what are known as partnerships. Partnerships, unlike the sole trading businesses or the sole proprietorship, is actually governed by a statutory provision, namely the Partnerships Act of 1980, which specifies that a partnership is a relationship between two or more parties carrying on a business in common with a view towards profit. Now, quite simply, because a partnership arrangement involves more than one individual, is why Parliament or is why legislation have decided to have the Partnerships Act in place. Now, the primary advantage of this, therefore, is the fact that since this is governed by statute, it has more security, more protections afforded to the partners, unlike in a sole proprietorship or a sole trader. But similarly, much like in a sole trading outfit, much like in a sole proprietorship, there is both joint and several liability. Whatever that happens will be spread across equally among the partners, or how they have essentially manifested themselves. Having said that, it is notable that there are certain other provisions or statutory provisions which are in place that essentially sever liability when it comes to partnership arrangements. One notable exception to this rule that I just mentioned is that of the Limited Liability Partnership Act of 2000. Essentially, what the 2000 Act specifies, liability is limited up to a certain point for general trading debts and is equally distributed among the parties. But other than that, any individual liability for negligence acts on their own account, on an individual partner's account, must be borne only by the parties that are responsible for it. It cannot be spread across equally among all the partners. Now, this in itself creates this tangent, so to speak, of partnerships, something that we wouldn't necessarily go into in depth here since we're talking about company law. But in terms of protections afforded, what must be understood is that a partnership is always a step beyond that of a sole trader or a sole proprietorship. A few other aspects that are quite notable in partnerships is that if you have multiple partners, 2 or more partners, and one such partner ceases or one such partner dies, this in itself is the end of the partnership itself. Now, you might want to not essentially equate, rather compare this to, for example, principles in property law that we've looked at in terms of co-ownership or joint tenancy, where when one of the joint tenants essentially ceases or dies, it essentially doesn't mean that the co-ownership arrangement or the joint tenancy ceases to exist. It just means that it lapses or falls onto whoever is remaining. This is quite different from that. Now, apart from that, being as it is, company law refers to primarily contractual arrangements, so to speak. These are matters between parties and matters between individuals, which courts of law are not quite happy or quite hesitant, for that matter, to get involved in. As such, partnership agreements can opt out of this 1980 Act as well, the Partnerships Act of 1980. But many partnerships prefer to have it conferred upon their partnership arrangements because there are a number of advantages and statutory safeguards which are afforded to the parties. Now, having said that, the fundamental aspect of doing business in the 21st century in modern days is that of companies. And this is going to make up the bulk of our syllabus, the bulk of our study of company law.